please ask for it. Okay. All right, with that, at this time, this court does call case number 128055, Juan Flores versus State of Kansas. Can I have appearances from the council? Can I have your name and bar number just to make sure I have it right?
Sure. Jonathan Sternberg for the appellant, bar number 25902.
All right. Ms. Allen? It's all right. We just got to make sure, and sometimes they flip. So thank you. You may be seated. And Mr. Sternberg, you may approach the podium.
Thank you, Your Honors. May it please the court. Again, my name is Jonathan Sternberg, and I represent the appellant, Juan Flores, who goes by Alex, and I would ask for 3 minutes of rebuttal.
3 minutes is granted.
As Your Honors know, Mr. Flores was convicted of 4 counts stemming from an alleged burglary here in Wichita in January 2017 and was sentenced to 20 years in prison, and he now appeals the denial of KSA 601507 relief. Your Honors, denying both of Mr. Flores' claims for relief in the 601507 motion was error, and this court should reverse and vacate his convictions. Mr. Flores' conviction rested ultimately on the eyewitness testimony of witness Sandra Torres. The trial counsel admitted that he conducted no legal investigation into the admissibility of the evidence that he had admitted at the first trial to impeach Ms. Torres, which resulted in that first trial in a mistrial, and no investigation further into Mr. Flores' 3 alibi witnesses. That's deficient performance under the first Strickland prong.
Now, what about his private investigator that he had? Was there anything there that would support the fact that an investigator may have reached out to the 3 alibi witnesses?
I'm glad Your Honor asked that, because I was going to start with the first point. We'll go straight to that. No, Your Honor, in short, not. So the counsel had testified that he believed he may have sent an investigator to talk to one of those 3 witnesses, John Pondo. So there were 3 witnesses, Ms. Vasquez, Ms. Trujillo, and Mr. Pondo. He said he thought that he had sent an investigator to talk to Mr. Pondo. But then when unusual for my own practice, I handled the underlying district court proceedings. I brought the file to him and I showed him, I asked where in the file is this, report from this investigator, and he went through and he eventually said, actually, he doesn't see that. Even then, though, it would only have gone to Mr. Pondo and not the only other 2 witnesses. So regardless, that's not an investigation. And further, the district court on page 249 of the record, in its opinion, says that Mr. Owens, counsel, had not actually investigated what the witnesses would say, and the only way he knew anything that they would say was from Mr. Flores' girlfriend. So no, that is not an investigation, certainly not a sufficient investigation. I want to go back to the first issue to start with. The district court in its judgment and the state in its brief described the ruling at the second trial as if the judge prohibited counsel from using Ms. Torres' false statements to police about the prior break-in unless the state opened the door. Your Honors, that's simply not what happened. On record volume 18, pages 26 to 27, the judge says, quote, "I'm open to it." This is him addressing Mr. Owens. "I'm open to it," meaning the evidence, "if you can show me I'm wrong." Well, this preserved the pathway for counsel to pursue this critical impeachment evidence. But counsel admitted at the 1507 hearing that he did no legal research on admissibility, it's pages 75 to 76 of his testimony, made no attempt to elicit the testimony from Ms. Torres, pages 72 to 74, made no evidentiary proffer, it's page 73, and frankly, ultimately on my questioning, admitted that he had misunderstood the ruling, and that's pages 75 to 76. Under Strickland, to have a hope of being reasonable, a so-called strategic choice must follow investigation, what the U.S. Supreme Court in Strickland itself called, quote, "thorough investigation of law and facts relevant to plausible options." Here, ultimately, Mr. Owens conceded there was none. And this is deficient performance for 2 reasons. First, even under counsel's mistaken view, the door actually was open to this testimony. The prosecutor elicited testimony from Ms. Torres that she recognized Mr. Flores by voice, her references to Facebook voice messages, and her telling police that she had changed from a Russian to a Puerto Rican accent in the person that she had heard. And then on cross-examination, and this is crucial, When probing this, Mr. Owens elicited her statement about talking to police, quote, "There was more said." That's record volume 18, page 226. Well, that clearly opened the door. What more was said? Of course, the answer to what more was said was what she had testified to at that first trial. But Mr. Owens didn't go any further. Your Honors, once voice recognition was affirmatively put into play, the law of Kansas, as in the Atkinson case from the Supreme Court in 2003, the Letourneau case from this court in 2005, permits inquiry into inconsistent prior statements about recognizing voices, which is what this was about. And I said that there were two reasons the district court was wrong. The second reason is that regardless, the district court itself was wrong that this wasn't admissible. This is a he said, she said case. There's no DNA, there's no fingerprints, there's no physical evidence. Ultimately, Mr. Ortiz, the person who was also involved here, he testified at both trials that actually it was Ms. Torres who had told him it was Mr. Flores, and that's how he got his own identification. So this all rests on Ms. Torres. Under these kinds of circumstances, Mr. Flores had the right to introduce evidence to show that Ms. Torres wasn't credible, which was, of course, as Mr. Owens himself admitted, the point to trying to bring this out in the first trial. But that's the McGallinas case from the Kansas Supreme Court in 2010, Atkinson that I cited before, and Rakestraw.
Are you presenting to us the issue of the admissibility of the evidence, or just the ineffective assistance of counsel related to the evidence?
Sure, one depends on the other, and here's why.
Okay.
The point here is that Mr. Owens had not investigated, after the district court says, I'm open to it if you can show me I'm wrong, Mr. Owens hadn't gone and investigated whether this actually would be admissible. In order to show prejudice and deficient performance, I have to show that it would have been admissible. And so I am arguing, and throughout our briefs, we've argued that it's admissible. For exactly.
Can I back up to the eyewitness identification?
Yes, Your Honor.
Wasn't there an issue over the defendant's tattoo on his face?
That's another reason that Ms. Torres gave for saying that she had recognized him. And that was one of the things that counsel certainly harped on. Absolutely. And that was, Ms. Torres said, I recognized because I could see from the little slit, she said that they were wearing ski masks with eye holes. And that I could see from there in the little slit the tattoo that Mr. Flores had on his face. Yes, she did say that. I don't see how that plays into this at all, though, Your Honor, because the point is, Mr. Owens still said, regardless, his strategy at both trials, including the second trial.
But then that go to identification, witness identification?
And prejudice?
So that too came from Ms. Torres herself. The question is whether Ms. Torres is credible, whether she actually had seen. I mean, obviously, sitting there in the courtroom, she can see that Mr. Flores, and this is in the second trial, mind you, has this face tattoo, right? Mr. Owens is attempting to show that she's not credible to begin with. So while, yes, taken as true, we're not saying it's insufficient evidence or something like that. The issue is whether Mr. Owens engaged in deficient performance by not impeaching her credibility in the way that he had in the first trial, as he still could have at the second trial. So the face tattoo, for these purposes, doesn't really matter. That's just what she testified.
Did she testify to the face tattoo in the first trial as well?
She did not, no. That's exactly right. So this came out for the first time at the second trial. In the first trial, it was just about voice identification. The second trial, she talked about the face tattoo and that she had seen him before on Facebook.
Now, they had met before, correct? They had met before.
She testified that they had, yes.
Okay, so it's not just the alleged burglary from past and then this incident. They had
That was her testimony, yes. And again, I'm not, obviously, 1507, I'm not saying her testimony is insufficient in some way. The issue is whether she was sufficiently
you said it was critical impeachment evidence?
Yes.
And I don't want to move too soon to your prejudice, so I'll let you continue, but I might ask about that when we get to prejudice.
Whether this was, so it was critical because this was her telling police that she had, that there had been a prior, initially she tells police that I recognized these voices from a prior break-in. And then when police investigated this, they determined, in fact, there was no prior break-in, or if there was, she actually had lied to the police before and said that she wasn't there at the time, even though now she said she was. And Mr. Owens was able to use this at the first trial to cross-examine her and then eventually to argue to the jury that she wasn't credible. And in that first trial, of course, the jury, and brought up Detective Alexander himself to testify to that. I want to ask, is the timer going into my rebuttal, or is that?
Don't worry about it.
Got it.
You'll get your rebuttal time.
I'm just
I
making
don't want
sure
to
I-
take that away from you. But when they, after his first trial, when defense counsel and the prosecutor spoke with the jury, did the jury rely on her, on the impeachment evidence of her as a reason why they found her
So,
not guilty? I thought they didn't pay much attention to that.
so at the, two responses to that. At the 60-1507 hearing, Mr. Owens testified that he talked to some members of the jury and they weren't swayed by that. The problem is twofold. First, that doesn't have anything to do with Strickland prejudice. Strickland prejudice requires prejudice to be assessed from the record, not from informal conversations. Second, 6441, which we mentioned in our reply brief when the state brought this up as an argument, expressly forbids any inquiry into the effect of anything on a juror's mind. That's not really permissible. The question under Strickland is whether viewing this evidence in its totality, under these circumstances, could a reasonable juror have gone with this? Also, I probably should have objected when Mr. Owens said.
Your point is we should pay no attention to the fact that a number of jurors told defense counsel that they didn't find that swayed.
That's correct, Your Honor, because we don't know how many jurors, we don't know who they were, and further, the law doesn't, that's not how Strickland works.
Sure, but would that be an indicator of a reasonable person? Would they be influenced by it?
No, so that would go to deficient performance, not prejudice.
Right.
The state only used this for prejudice, as did Judge Sirios. As to deficient performance, Mr. Owens never testified that this was a reason that he decided not to bring up this evidence. To the contrary, he kept Detective Alexander under subpoena the whole time during the second trial. He testified that his intent was to bring up this evidence, which is why they had that colloquy with the court at the opening of the second trial, that he did still intend to bring this up. He never testified at any time that he decided not to because of the juror's testimony. He said he decided not to because he believed the judge told him he couldn't. And then, of course, I showed him on on examination why that wasn't correct.
Before the judge said, I'm open to it if you can show me I'm wrong, the judge said no. No?
He said he believed that the state was correct and that this wouldn't fit 6422, but then at the end he says, I'm open to it if you can show me I'm wrong. He was wrong because of the line of cases that hold that under, sorry.
No, I'm sorry. Go ahead.
That under 6422, if this goes to the credibility of the, he said, she said witness, it still can be brought up.
In the procedural posture of this case, what about the direct appeal of that issue? If you were going to direct appeal, would you argue that the judge ruled the evidence inadmissible?
So this couldn't have been an appeal directly. So if this had been preserved correctly, I would have brought up a claim of ineffective assistance of appellate counsel, but it was never preserved. So the issue, and I got actually Mr. Owens to admit to this too, he didn't make an evidentiary proffer, which would have been crucial to try to bring in this evidence at the appropriate time. He never asked Ms. Torres while she's on the stand to elicit an objection from the state, what she had told police, that sort of thing that he wanted to bring up.
Because of the lack of contemporaneous objection?
6460, absolutely. It wouldn't have been preserved for appeal. It's something I was concerned about, and if it had been preserved, I certainly would have said appellate counsel was ineffective for not bringing
So that
this
was
up.
an issue you could have brought up in your 1507.
We certainly did. That Mr. Owens had, that part of the ineffectiveness here, Mr. Owens had failed to preserve this issue for appeal.
Right.
We
I
certainly
understand.
brought that up.
Yeah, okay.
Absolutely.
Okay.
I understand.
Well, I see I'm quite out of time.
Did you want to get to prejudice? I'd like to talk about that.
I would love to talk about prejudice if you'd like me to, Your
If you
Honor.
could just give us a short minute of the time, I want to be fair to the state.
Certainly, I do as well. Prejudice for both issues really comes down to, well, it's slightly different. But the main issue for prejudice here is this is a pure identification case. As I said before, there's no DNA, there's no fingerprints, there's no physical evidence, there's inconsistent statements between witnesses, between trials. Torres's and Ortiz's identifications were intertwined. When you have this kind of evidence, in the Magallanes case, the Kansas Supreme Court says this comes down to the credibility of that complaining witness. And if there's evidence from which the jury could find that they were not credible, then in this context, the lawyer fails to introduce that evidence, the prior break-in to impeach her credibility, and then the alibi witnesses to show that, in fact, Mr. Flores was not there at the time, and that's another reason that she's not credible. That's prejudicial.
Well, didn't the attorney make a decision that the 3 alibi witnesses were family members, and his prior experience told him that that didn't go well with the jury?
Yes, he did, Your Honor, and I'm glad you said that, because that's the reason, the actual reason, not any of these other things that, oh, he had investigated them or something like that. That's the actual reason that Mr. Owens said that he didn't bring up the alibi witnesses. The problem with that is, A, he hadn't actually talked to them. Certainly, even without an investigator, hadn't talked to 2 of them. And in both the Sanford and Shumway cases, and then the Tolliver case from the Seventh Circuit, but in Sanford and Shumway, this court held that that's not a good enough reason. If you haven't investigated those witnesses, that's not a good enough reason to bar them. Potential bias is a reason to impeach a witness, certainly, not to avoid talking to them in the first place. In Shumway, it was the defendant's wife who the court found the lawyer was not effective for failing to bring up. And he gave the same reason, saying that it was a family member. And this court reversed and held that it was ineffective assistance of counsel. This fits both Strickland prongs for both issues. And unless the court has any further questions, I would give the rest of the time to the state.
Thank you, and you still have your 3 minutes for rebuttal.
Thank you, Your Honor.
Mr. Steinberg.
Good afternoon, and may it please the court. I will start where Your Honor, Judge Pickering started with investigation. And didn't Mr. Owens have an investigator? The testimony during the 1507 hearing was that he believed he had an investigator. Mr. Sternberg did show him his file. There was no report from that investigator. But the law does not require an investigator speak with a witness. What the law says is that some investigation must be done. In this case, Mr. Owens conducted an investigation. He spoke with the defendant. He spoke with the defendant's girlfriend. They told him what these family members would say. He filed an alibi notice. He knew the names and addresses of these witnesses. So that it's not that there was no investigation done. There was some investigation done. It's just in this situation, what Mr. Flores wants is investigation that he did plus more.
So oftentimes when there's an alibi witness and the investigation merely consists of what the defendant says the person will say, the lawyer determines to not go further because it isn't an actual alibi witness. Is that what the state is arguing? Like if the defendant accurately reported what the people would say, would they have not been actual alibi witnesses?
That is not my argument today. My argument today is that Mr. Owens was told what the people would say by the defendant and the girlfriend, and that based on that information and his experience, and it was not just because they were family members.
Okay, what were the other reasons?
Because in his experience, if you have a person say just that they were that the defendant was at another place when this crime occurred without corroborating evidence, uncontrovertible evidence, something else other than this person's statement, then the juries can shift the burden. The juries, without being told to, maybe not even intentionally, but it then becomes, unless you have something more, it becomes the jury, do I believe the alibi witness or do I believe the state's witness? And in his experience, without that uncontrovertible evidence that corroborates what that witness is saying, it's dangerous to put that person up there, because then even if unintentionally, if a jury does not believe that alibi witness, especially an alibi witness that may be invested in the defendant not being convicted, that if the jury finds that alibi witness to be not credible, then they won't hold the state to the burden like they should.
And would one way have been to determine if there was other corroborating evidence? Would it have been to maybe talk to the witnesses?
If what the defendant told Mr. Owens was true, they will tell you that I was asleep in the apartment on the couch at this time. That's what they will say. We don't know what the rest of that conversation between the defendant and the attorney was, because that was not something that was questioned at the 1507. Did you ask him if there was anything that these witnesses would be able to point to show that you were there? We don't know, because that's not part of the record. That conversation could have happened, but we don't know that it didn't happen based on this record, because that was not the question. Regarding the testimony of the identifying witness, this is a situation where I was confused in reading the transcripts, because when looking at the first jury trial and then looking at the second jury trial, I don't believe the transcripts of the interview were ever introduced into evidence as an actual exhibit for people to see. What Mr. Owens testified to in the 1507 hearing, however, was that he didn't pursue the impeachment testimony regarding this prior break-in because he did not believe that the state opened the door, which the court ruled, I'm going to find that if it's beyond the scope, then you're not allowed to discuss it unless they open the door. I'm paraphrasing, obviously. And so, in his opinion, that door was not opened. What confuses me is that in reading through the transcripts, and Mr. Owens even says this in his testimony, the identifying witness, Ms. Torres, never specifically said it was the defendant's voice that she recognized from the first break-in. And the detective that testified in the first hearing on cross-examination, he said, I just assumed she was there by the way she was talking. I never asked if she were there. She did not specifically tell me she was home during this prior break-in. So we're assuming that there's information out there that's not in this record. I don't know if she said, I recognize the defendant and I was home during this prior break-in. What we know from the testimony is at the first trial, when Mr. Owens brought it up, she specifically said, no, I was not home during that break-in. The detective said, from the way she talked about it, I thought she was. But when I went back and I looked at the report, there was no suspect information because there were no witnesses. And it was a prior break-in of 2 individuals. So it wasn't 3 individuals, it was 2 individuals. Mr. Owens even says she never specifically said it was the defendant's voice that they recognized from that prior break-in.
So I'm sorry, is the point here that you think the door was not open?
I believe that the door was not opened by the state on direct examination.
Okay.
And even if it had been, and this was Mr. Owens' point, even if it had been, he was there. He was doing the trial. He's observing the witness testify. He's observing the jury's reactions to it. He did not find that testimony to be compelling at the time of the first trial. That was confirmed when they later spoke with the jury. And so a reasonable person at that time would hear this and say, I have an opportunity to be better in my second trial. And Chamberlain v. State, we evaluate the conduct from counsel's perspective at the time. So at that time, he's hearing, we didn't really care about that. This is the information that was meaningful to us. So that was his focus. He did say in the 1507 that he was still intending to do that, but the morning of the evidence, the morning of the first day of evidence was when the court made the ruling, I'm going to find it's outside the scope, and therefore you can't bring it in unless the state does. Yes, the court said, I am open to allowing it if you can show me that you're wrong. And we now fault Mr. Owens for not doing legal research. When the trial then started, he has a number of witnesses testifying at that time. That same witness, Ms. Torres, testifies that day. And so this is a man who's doing this jury trial for the second time, realizes that the evidence was not as compelling for him. This jury has told him that it's not compelling. She doesn't actually say that she recognizes the defendant's voice from that first prior break-in. And the detective never followed up and said, were you actually home during this first break-in? So I think with all of that information, his focus was on, I know that there are some discrepancies in the masks that she described. There are discrepancies in the tattoos that she described. If these Facebook messages come in, there's some discrepancy there because she didn't tell law enforcement about these Facebook messages. So that's what he was focused on, and that's why he didn't pursue and didn't preserve for appeal that evidence, because he thought he had more compelling evidence to go forward on.
So, but the other compelling evidence was also sort of credibility related.
Correct, it was.
So, go ahead.
Can you remind me, at the 1507, did he acknowledge that's why he didn't object?
I don't know if he specifically stated it. I know the court found that he pursued more compelling evidence instead of preserving
Right,
the
I
issue.
don't want to make the leap, which your argument suggests, which is he stated it. So
Right.
I'll leave it to Mr. Sternberg to correct the record if he needs
Okay.
to at rebuttal.
Okay.
So I think it's the state's contention that the judge said, I don't think this evidence can come in, and unless the door is opened, and then that the door wasn't opened.
On
And s-
direct.
And so then, why not preserve an objection about that?
Because, and I think I can answer, I think Mr. Owens at the 1507 never said that he didn't find it compelling. What he said was, I thought other evidence was more compelling. And so, if you're not preserving you don't preserve it for appeal because you don't think that's the evidence that's going to win. Defendants are constitutionally guaranteed a fair trial, not a perfect trial. And at this point, Mr. Owens was taking the evidence as it was coming in. He was taking the court's rulings as it was coming in. He was going off of what he saw was successful during the first hearing. He saw the questioning, how it was going during the second hearing. And so that's why he made the tactical decisions that he made. And
So are you suggesting that a trial attorney who had over many years of experience, and since Kingman came out in 2009, really hammering that trial attorneys have to object in order for that objection to be considered an appeal, that he made a strategic decision not to object, even though it does no harm to anybody, but to just object?
that is what he testified to.
That's what he testified to?
I believe so, yes.
Okay. All right. Thank you, Ms. Allen. Appreciate that.
If I may, I'll just address both prejudice together. So even if this court were to find that he should have followed up on this impeachment testimony and that he should have called these alibi witnesses, there was no prejudice. And what I can tell the court in reviewing for this oral argument today, one of the biggest changes was there was a different prosecutor, so evidence came in differently. One of the biggest pieces of evidence that came in was a Facebook profile picture, which was objected to, was preserved for appeal, with the defendant wearing the mask and the tattoos exactly as she saw them that day that she had told law enforcement about. That photo was not admitted at the first trial. It was admitted at the second trial. Mr. Ortiz, I believe, the victim of the shooting, testified that in the second trial, well, he said, my girlfriend told me, but I knew him. I knew him. I already knew him. And so, yes, the evidence relied on Ms. Torres's eyewitness testimony, but the victim of the shooting kept saying, but I knew him. I already knew him. And so you have more than just her statements. You have the picture that comes in with the masks as she described, showing the tattoo. You have the Facebook messages that come in. And I would say that Mr. Owens cross-examined very rigorously and thoroughly on the discrepancies in the mask description, the tattoo description, the Facebook message description. And even if we believe the alibi witnesses, because they testified at that 1507, so even if the alibi witnesses had testified at the trial based on their 1507 testimony, there were discrepancies in their testimony as well.
Can I interrupt?
Yeah,
I don't want to take you off, but I just want to pause for just a moment and help me out with the record. So the first trial, the Facebook picture
Correct.
of Mr. Flores
Correct.
wearing a mask was not admitted.
Correct. And for context, there was a motion in limine for that, and it was more prejudicial than probative was the argument because it had profane language underneath, it had a poster regarding gang
Plus
movies.
it puts him in a mask.
However,
It puts him in a mask.
it puts him in a mask, but what they did is they cropped it, so none of the profane language, none of the gang statements, anything like that was removed from that photo. And what the court found was that this is not a prior bad act. This was something that Mr. Owens rigorously cross-examined on and explained maybe why she was confused on which side of the face his tattoo was on.
And then, so it's then admitted in the second trial.
It is admitted at the second trial.
And what was the court, so I apologize, I'm
No.
just going on a little tangent, help me out here. And so the judge allowed it in the second time?
Yes.
And that boosted the state's case about identity, that the state did not have the first trial?
Yes, and what was admitted at the second trial was not that original picture, it was a cropped picture. So the original picture was admitted for the purposes of appeal only, so it was preserved for the record. The cropped picture is what the jury saw. And then that issue of allowing the Facebook photo in was an issue on direct appeal.
Right, so it was objected to?
Correct,
Okay,
yes,
thank you.
yes. So to wrap up, I would ask this court to find that there was no deficient performance when you consider his conduct based on the circumstances and his perspective at the time of those hearings. And he did an investigation. Maybe it wasn't the best investigation that he could have done, but that doesn't mean he didn't do an investigation. And even if he had done those things, based on the evidence that was presented at trial, there was no prejudice. And we'd ask that.
I'm going to interrupt, apologize. He had hired an investigator.
He said he hired an investigator. Mr. Sternberg pointed out at the 1507 that there was no investigative report regarding the alibi witnesses.
Right, but overall, he had hired an investigator.
According to his testimony at the 1507. Yes.
Thank you, Ms. Helen.
Thank you.
Counsel, you have 3 minutes.
Thank you, Your Honor.
If you could start once we get the clock working, if you don't mind. You may begin.
Thank you, Your Honor. I think the state and I must have read 2 different transcripts for some of this. Let's start with Mr. Owens and the preservation issue, which I did question him about at the 1507 hearing. He testified that he routinely made objections to preserve issues for appeal. This is pages 63 to 65 to begin with. He said his general philosophy is to bring in what I can until they make me stop, kind of like Heyman says, unless it's blatantly wrong. He agreed he could have questioned Ms. Torres about the prior break-in and argued why it was admissible if the state objected, which would have preserved the issue. He agreed he could have made an evidentiary proffer of her and Detective Alexander's testimony to preserve the issue. And then, crucially, pages 84 to 85, he testified, when I asked him, he said he did not make a conscious decision not to object to this evidence. The state
But
just said he did.
we'll still need to get to the prejudice, right?
I agree. The prejudice, though, is what if the prejudice becomes, for both of these issues, these are about missing evidence, right? One's the impeachment evidence, one's the alibi witnesses. If the jury had heard that impeachment evidence, is there a reasonable likelihood that it would have made a difference? Same thing with the alibi witnesses. And the answer is yes, for both. The alibi witnesses, certainly. And Judge Hurst, I know you were involved in the Alvis case in 2021, where the court held that there was deficient performance but not prejudice. And the reason the court found there was not prejudice there, it was a very different posture, was it was in a motion for new trial hearing after a bench trial as opposed to a jury trial. And in a bench trial, of course, the judge would be able to determine whether the person was credible. He said, I don't find these people credible. The difference here in a missing witness case is we don't have the ability, and Judge Sirios certainly, and he didn't attempt to say that, we don't have the ability to determine whether the jury would have believed them or not. Instead, we ask, if the jury had believed those witnesses, would it have made a reasonable difference? And as this court held in the Shumway case and the other alibi cases that we cite, it would have. We cite a case called Nwoye from the D.C. Circuit, written by now Justice Kavanaugh back when he was on the D.C. Circuit, where he explores this question and says when you have a missing witness issue in a 2255, which Kansas follows the law for 2255s, if you have a missing witness issue, the question is if the jury believed that witness, would it have made a difference? These are alibi witnesses.
What about
Of course it would have.
argument that there's more evidence of identification in the second trial?
So the more evidence of identification was, for the first time, the witness now says she sees a tattoo. The tattoo is not mentioned in the first trial. And now they have this.
But she had told the police about the tattoo before that, right?
I don't know if the evidence is there of that. At the first trial, she said, I recognized him from his voice. And that's why all this stuff happened about the voice, that she had recognized his voice from before. The point, though, is at the second trial, it's still her testimony. They're putting up this picture and saying, is this the guy you saw? And she says yes. The question is still, is she credible? If the jury doesn't believe her, and that's what Mr. Owens was trying to show, if the jury doesn't believe her, the jury doesn't convict. She's the linchpin in the entire thing. I see I am out of time. We ask your honors to reverse and vacate Mr. Flores' convictions.
Thank you, counsel.
Thank you.
Okay, all right, thank you, counsel. I want to make sure
Thank
we
you,
get
Honors.
all our questions asked. Thank you. All right.
Thank you.
We will take this matter under advisement. We appreciate the work that went in preparing for your arguments
Yeah.
today.
You guys did a good job in your